And here we are again, everyone. It's Rob Ryder. Sunday, March 2nd, 2014. Evidence of insurrection. It's time to go tell the English sheriff. You can contact me at courtofrecord@AOL.com. And my phone number, 616-712-6179. Oops! My rent's late. Can you and will you donate? If you ever thought about it, now's the time. My rent's late. Can't buy no food. Can't pay the rent. Can't pay the electric. Can't pay the cable. I got lots of can'ts right now. Got to deal with those. PayPal account name is, that's the account name actually, ashleyritluski@gmail.com is the account name. Or snail mail to Robert Ritluski, 10955 14 Mile Road, Rockford, Michigan, 49341. Okay, the English sheriff, what the hell's that all about? Well, for one thing, I guess we should start here. Illinois' compiled statute says that the common law of England, so far as the same is applicable, and of general nature, and all statutes or acts of the British Parliament made in aid of, or to supply the defects of the common law, and no doubt it has many defects, prior to the 4th year of James I, excepting the 2nd section of 6th chapter 43 Elizabeth, and the 8th chapter of 13 Elizabeth, and 9th chapter 37th of Henry VIII, and which are of general nature and not local to the kingdom, shall be the rule of the decision, and shall be considered as full force until repealed by legislative authority. All the way back to Henry VIII and further, the common law of England is being used here in what you think of as America. We're under the laws of England. Yeah. Ain't that something? Is this where it says something about the law of the land? Prior to the 4th, second nature day, blah, 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 blah. Yeah, that law of the land stuff bothers me because that could be construed to be the Magna Carta, which was the constitution of the Jewry between the Jews and the king, and I ain't no Jew. I ain't got no Magna Carta. Right? I'm a Christian. Got God-given rights. I'm in the empire, not the empire, the kingdom of heaven, here on earth. It's already here. We just need to take it back. So anyways, so the laws of England do apply, so, well, shit. Let's think about that, shall we? If we were to look at, let's get a few definitions down. What is rebellion? Taking up arms traitorously against the government. And in another and perhaps more correct sense, rebellion signifies the forcible opposition and resistance to the laws and process lawfully issued. Now, we have been told, not myself, but Bobby in Arizona has been told by a legislative researcher at the legislature in Arizona, they're not following the laws. They're not following the laws. They don't have to have a sworn complaint. He's been told that by an assistant prosecuting attorney. We don't need a sworn complaint. When right there in the law it says, by gosh, you need to have a sworn complaint. You want to, if it's a criminal matter, you got to have a sworn complaint. So Bobby had mentioned, he said, well, it sounds like there's an insurrection going on. And he said, that really kind of got the lady's attention. We're going to push that a little bit harder this week. But rebellion, right? Forcible opposition, resistance to the laws and processes lawfully issued. The law has been passed. If you want to bring a complaint against somebody, you need to swear to it, and they're not doing it. That's opposition with force. Anything that's done forcibly, right? Because they're using guns and bringing you in, coercing you, and everything else. Well, that's disturbing the king's peace. So we need to call it the sheriff. Usurpation, the unlawful assumption of use of property which belongs to another. An interruption or disturbing of a man in his right and possessions. Well, shit, that happens frickin' daily, every time they take you to court. According to Lord Coke, there are two kinds of usurpation. When a stranger, without right, presents to a church and his clerk is admitted, there's something being said there that I got to figure out, because that's one of those deep things, right? 4 little phrases put together that really mean something. The next one's a little bit easier. When a subject uses a franchise of the king without lawful authority, such as they say that they're the county treasurer when in fact they haven't taken the proper oath. And we'll look at some examples here shortly. Usurpation government, the tyrannical assumption of the government by force contrary to and in violation of the Constitution of the country. There's some of that going on. When there's a usurpation of any kind and you find it, you're supposed to petition for a writ of quo warranto. Quo-warranto. Quo warranto. And if they find that they violated, via the quo warranto, that they violated a franchise, they are supposed to shut them down. Make that franchise court go away and not following the law. Insurrection or rebellion of citizens subject to the country against its government. Okay, so insurrection going on. Rebellion of citizens or subjects of a country against its government. They're not following the laws and they admit to it. Alright, so let's just call it what it is, man. It's a frickin' insurrection. So, I'm just going to speed read through this because it's rather long, but you ought to go find it for yourself. Of Subordinate Magistrates, Commentaries of the Laws of England by William Blackstone, Book 1, Chapter 9. Let's begin. Of Subordinate Magistrates. The ones we're really interested in is just this. We're going to start with the sheriff. The sheriff is an officer of very great authority in his kingdom. In this kingdom, his name being derived from two Saxon words, shire reeve and bailiff, or officer of the shire. Sheriff does all the king's business in the county. He is entirely independent of and not subject to the earl. Custody of the county to the sheriff and him alone. There's one dude runs the county, and he ain't wearing a frickin' 10-star. Sheriffs were formerly chosen by the inhabitants. For in the Gothic Constitution, the judges of their county courts, which office is executed by our sheriff, were elected by the people. The sheriff is the judge of the county court. You don't think you have a county court? You do. They're just not calling it a county court. Sheriff should from thenceforth be assigned by the Lord Chancellor. Okay, so they used to be elected by the inhabitants, and then they said, well, that's a little bit too loosey-goosey. We're going to give it to somebody else to make the decision. So the Chancellor, the Treasurer, the Chief Justice, Chief Baron are to make this election on the morrow of All Souls in the Exchequer, and the King's letter patent appointing the new sheriffs commonly to bear a date of the 6th day of November. Right? So, someplace we might be able to actually find this guy's oath and bond, right? It has something to do with the Exchequer and the treasurer and so forth, except, damn, the frickin' county treasurer didn't take the right oath, so it isn't him. Who are these people? But then they changed it to a different term, the Michaelmas term. And there are nominated 3 persons to the king, who afterwards appoints one of them to be the sheriff. This custom of 12 judges nominating 3 persons, borrowed from the Gothics. Among the Gothics, 12 nominators were the first elected by the people. Blah, blah, blah. So, this just tells how all this shit happened over the last, who knows how many centuries, many centuries. The idea is there's a guy who's called the sheriff. Sheriffs, by virtue of several old statutes, are to continue in their office no longer than 1 year. And yet it has been said that a sheriff may be appointed during the king's pleasure, and so is the form of the royal writ. Right? Should only be a year. Could be for the life of the king, king's pleasure. Now, if the king of the kingdom is the Lord Jesus Christ, who it is, and he doesn't ever die, then he's sitting there at the king's pleasure. The king isn't going to die, so he's sitting there for life, as long as he follows the rules. And, to me, the only one that could remove him from office then, well, through the food chain, is going to be the Pope, because the Pope is the vicar of Christ. He's Christ's deputy. He's not replacing Christ. He's just his frickin' deputy. He's his chancellor. and we are in the kingdom of heaven. So this judge, this one guy, this sheriff, the English sheriff here in America, runs the county, and everybody else is a pretender. We shall find it is of the utmost importance to have the sheriff appointed according to law when we consider his power and duty. These are either as a judge, as the keeper of the king's peace, as a ministerial officer of the superior courts of justice, or as the king's bailiff. Right? In judicial capacity, he is to hear and determine all cases of 40 shillings value or under in his county court. He runs the county court. Well, what courts have, less than 40 shillings? Right? It's a court where they're not asking for money. Right? It has nothing. They don't want. It's not damages. Courts of law are for damage. Right? Courts of equity, courts of justice are for justice. I want the property. I don't want your money. I want my damn property back. He is likewise to decide the elections of knights of the shire. Now, this is where we can get some idea who this guy is, right? He's like the election. He's in charge of the elections of the county. Who's the top dog? And we'll see some other things that lead to this. The top dog in the county of elections is the sheriff. As keeper of the king's peace, both by common law and special commission, he is the first man in the county and superior in rank to any nobleman therein. He is the top dog in the county. He may and is bound ex officio, officially, to pursue and take all traitors, murderers, felons, and other misdoers, and commit them to jail for safe custody. He is also to defend his county against any of the king's enemies. Well, we're in an insurrection. They're not following the king's laws. He's forbidden to hold any pleas of the crown, in other words, to try any criminal offenses. He doesn't try criminal cases. He may have somebody else do it, but he doesn't do it. Because he's the executioner of justice. The sheriff is bound to execute all processes issuing from the king's courts of justice. In criminal matters, he also arrests and imprisons. He returns the jury, and he has custody of the delinquent. So who returns the jury in a criminal case? I don't really know exactly what they're talking about. I'm just looking for hints to figure out who it is. I have my own way I'm going to try to find them, but anyways, he must seize to the king's use all lands devolved to the crown by attainder or escheat, must levy all fines and forfeitures, must seize and keep all waifs, wrecks, estrays, strays, and the like, unless they be granted to some subject, and must also collect the king's rents within his bailiwick if commanded by process from the exchequer. Right? So all the paperwork, the liens and titles and that kind of stuff, he has to know what they are. Otherwise, how could they say it's a wreck or a stray or whatever, right? He has to have something to go by, and that's the office of the recorder. Right? The chancery, that's where all the records are. That's what the law says. They want to know what the law says, they go to the exchequer or to the chancery office of the recorder and look at it. Well, it says this guy's the owner. He's the owner. To execute the various offices the sheriff has under him many inferior officers and under sheriff, bailiffs, jailers who must neither buy, sell, nor farm their office on forfeiture of £5,000. That was awful expensive, man. £5,000 back in Blackstone's day. The under sheriff usually performs all the duties of the office. A very few only excepted, where the personal presence of the high sheriff is necessary. But no under sheriff shall abide in his office above 1 year, and if he does, by statute, he forfeits £200, a very large penalty in those days. Well, not compared to £5,000. And no undersheriff or sheriff's officer shall practice as an attorney during the time he continues in such office. Now, I've seen certain judges that, they or certain offices, looking through the structure of the county and the state and so forth, where it says they can't practice law. All right, well, those are either the undersheriff or the sheriff's officer, which is a bailiff. But these statutory regulations are shamefully evaded by practicing in the names of other attorneys and putting in sham deputies by way of nominal undersheriffs, by reason of which, says Dalton, the undersheriffs and bailiffs do grow so cunning in their several places that they are able to deceive, and if it may be well feared, many of them do deceive both the king, the high sheriff, and the county. Got a bunch of deceivers. And these deceivers are the ones that are actually sitting in the courts, wearing the black robes. We call them judges. They could be called an undersheriff. They could be called a bailiff. Bailiffs or sheriff's officers are either bailiffs of hundreds or special bailiffs. Bailiffs of hundreds are officers appointed over those respective districts by the sheriffs to collect fines therein, to summon juries to attend the judges and justices of the assize and quarter sessions, and to execute writs and process in the several hundreds. That sounds like, a guy that I would call a district court judge. The coroner is also a very ancient office of common law. He is called a coronator because he principally doeth pleas of the crown, and of such wherein the king's most immediately concerned. And in this light, the Lord Chief Justice of the King's Bench is the principal coroner of the kingdom. Alright, so pleas of the crown go to the Chief Justice of the King's Bench in the kingdom. The Lord Chief Justice of the King's Bench is the principal coroner. And so he's the guy that you would send a plea of the crown to. And that to me just sounds like they're either saying it's the chief judge of the Supreme Court, the way you see the guy's picture and smile a mug when you look on the websites, or it's another court that we're not really seeing. But nevertheless, he's the chief coroner. But there are also particular coroners for every county of England, usually 4, but sometimes 6 and sometimes fewer. He is chosen by all freeholders in the county court. The county court, there's them freeholders again. Yes, they do exist. You can find freeholders today who are concerned in matters affecting the liberty of the people. Then it goes on to say, however, it's kind of fallen into the coroner is chosen for life, but may be removed either by being made sheriff, because the coroner can be the sheriff, but the sheriff can't be the coroner. Yada, yada, yada. Another branch of his office is to inquire concerning shipwrecks and certify the wreck or not, and who's in possession of the goods. Yeah, it sounds like probate judges to me, but I don't know. Then they got justice of the peace, the keepers of the records of the county. That the principal is, right, the keeper of the records of the county, the office, the recorder, and justice of the peace. So these subordinate magistrates are all under the sheriff. If there's a sheriff, he's the top dog. So the justices of the peace work for the sheriff, and one of them is the keeper of the records of the county. Right? But it's a justice of the peace. It's not county recorder, unless that county recorder is a justice of the peace. Wrong office. It's somebody who has the office of justice of the peace. There has to be a way to find that out, because those are commissioned offices, just like a notary. And in the county in Michigan, all the notaries are on file with the county clerk. I never checked. I wonder if justices of the peace are. Of these, some had and still have this power annexed to other offices which they hold. Others had it merely by itself, which were named custodials, keepers of the peace. And one of the things it said was the circuit court judges. This is in the Michigan Constitution. That the circuit court judges were custodians of the peace. If I'm not mistaken, that was the words they used. So, anyway, lots of good stuff in here to read, but I don't have time to go through the whole thing. The coroner is also a conservative of the peace within his own county, as is also the sheriff. Excellent. Now, Roe found in Illinois, in her county, I can't remember what we're looking at, but there it was, boom, talking about these coroners being conservators of the peace. They were not the coroner, and I want to say assistant, but it could be, maybe it was deputy coroner. And they had 4 deputy coroners. So she went to the coroners to talk to them about being justices of the peace or conservators of the peace. And the lady's eyes got big and wide and said, "Oh, no, we just handle dead bodies." Right? Again, don't know what to do with this yet, but we're going. It's good to go and make them sweat. Ask them a question based on what it says. What it says here, it says you're a conservative of the peace, and then I should be able to give you my complaint. I want to point out a crime. You're a conservative of the peace, right? I claim the king's peace. There's a breach of the peace. And make him say, well, if it isn't you, then who is it? Because this law says it is, unless there's an insurrection. Now, that's what Bobby's going to do on Monday, or, maybe he will. We'll see. We talked about it a little bit. Call this lady back, say, look, if there's an insurrection going on, where do I take my complaint to? I believe it's the county commissioner or the county emergency manager, and we'll look at his stuff in a minute. It looks like that's a place you would take a complaint about an insurrection to. Right? Because if you're telling me they're not following these laws, then we must be in a state of emergency. Is that not correct? And you think about it, we probably are in a state of emergency because the president writes executive orders. And the only time he can do that, from what I understand, is in a state of emergency. And the first one was written with Lincoln, and, they've been writing them ever since. The war never ended between the North and the South. There's still an insurrection going on. The insurrection continues. Right? You had these two sides, had different versions of what should happen. You had the South that said it was okay to make man your property and make him a slave and run your, take care of your business for you. That's fine. We're good Christians, but what the hell? We're going to make you a slave. And in the North, they said, well, that doesn't look so good. Maybe it isn't quite so Christian to make people slaves, actually call them slaves. We got a better idea. We're going to get free labor. We'll just have them work their whole life, and then we'll take their shit later. And that's what we're in today, right? That's the system that won out. You work your whole life, and then they lie, cheat, and steal, and take your property. Good Protestants, set the system up. It's a wonderful thing. Yeah, that's Protestantism at its best. That's why there's 33,000 versions of it. Don't like it the way it is? Go ahead and make your own church. Okay, let's see here. And if you can, please do donate. Again, donate. PayPal. Account name is ashleywertlewski@gmail.com. Or snail mail Robert Wertlewski 10955 14 Mile Road, Rockford, Michigan 49341. Sorry, I got to ask. I wanted to point out, this is in, these are just little things I want to get out of the way so we can get on the meat and potatoes. Okay, so in the Michigan court rules, there's a section on the administrative, we'll look at the top in a minute. Administrative rules of court, I think it is. Rule 8.122, claims by clients against attorneys. Attorneys are officers of Michigan's one court of justice and are subject to the summary jurisdiction of the court. Forget everything else it says afterwards. Understand this. Attorneys are officers of the court and subject to the summary jurisdiction of the court. The circuit court of the county in which an attorney resides or maintains an office has jurisdiction on verified written complaint, sworn complaint of a client or anybody else, as far as that goes, and after reasonable notice and hearing, to enter an order for the payment of money or the performance of an act by the attorney by which law or justice may require. Right? You don't want to fire your attorney. You want the son of a bitch to give you the proper defense or the proper representation. And if he isn't going to do it, and you say, look, You say, hey, them guys over there, they're not following the law. See, they were supposed to do this or this or this, and you can point it out because you're smart enough. You've seen it in the rules. You can read the rules. Says what it says. Show you some more examples. They're not doing it. Well, then you're supposed to give your complaint to the circuit court of the county. Circuit court of the county. Circuit court of the county. So, in Michigan, in every area, right, we have these circuits. For instance, here in Kent County, they call it the 17th Circuit Court. Well, that doesn't say Circuit Court of the county. That's the 17th Circuit Court. In Montcalm County, it's called the 8th Judicial Circuit Court. Well, that doesn't say Circuit Court of the county. I think this is real interesting. Circuit Court Administrator is the judge, right? Because that's actually what it is, right? This isn't the Circuit Court, right? This may be the administrative end of the Circuit Court, but it's not the Circuit Court. It's not the judicial end. And the court administrators are actually the judges of this court. 18th Judicial Circuit, that's in Bay County. Again, it doesn't say anything about being the circuit court. Right, it says here the circuit court's the highest trial court of the state. Well, it is. But not the 18th Circuit Court, the circuit court. Not the 18th, but the circuit court. Right, so where is the circuit court of the county? Because none of these seem to be it. I mean, this one talks about, let's read this one from Kent here. The 17th Circuit Court will provide a system of justice that assures equal access to the fair and timely resolution of matters brought before the court. The Circuit Court is the trial court of general jurisdiction in Michigan. It has jurisdiction over actions except those given by state law to another court. What this just said, right? It's going to give a fair and timely resolution to matters brought before the court. Right, so this is the administrative end of the judicial end of the court. The problem is we are not putting our paperwork into the circuit court. We're putting it into the 17th Circuit Court, not to the circuit court. The circuit court has original jurisdiction in all cases involving more than $25,000, in all criminal cases where the offense of felony or serious misdemeanor, all domestic relations, all child abuse, neglect, or other delinquency cases, right? So if you want to know where the circuit court is, well, that's the kind of things they have jurisdiction over. The circuit court also hears appeals from lower courts, appeals from local government boards, right? Administrative hearings, in other words, and appeals from some administrative agencies of the state government. Blah, 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 blah. Now, while I was sitting in jail and going to traffic court in jail, and I've told the story numerous times, I'm sitting there and it's my turn to listen to the judge, and he wants to talk about these criminal, or she does, these criminal complaints I had put in before. I sent like 7 of them out at the same time, but 3 to this particular district court that I happen to be in now. Already in jail. Long story, but it doesn't matter. And she's going through them all. She says, well, it's not that you're not correct, right? When somebody says it's not that you're not, right, 2 negatives make a positive. That's the way it works in logic, right? So not that you're not correct. I am correct. I'm just not inclined to issue any warrants. That's what she said to me. And then she said, and in the case you're here for now, boom, $40, or, spend a couple more days, or whatever the hell it was, right? And I said, well, hell, man, you're just perpetuating the fraud. And she said, well, if you want to appeal my decision, you can appeal it to the circuit court. And at the time, it's like, well, okay, well, I put my complaints into the district court, like it said to do in the compiled laws. And she's saying it's not that I'm not correct, but she's not going to issue a warrant. But in the compiled laws, it's lowercase district court. When I walked in the building, it was uppercase district court. So which circuit court is she talking about, right? All these kind of things go through your head, blah, 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 blah. So, Right? So where is this circuit court they're talking about? Circuit court of the county, right? Not the 13th, 16th, 18th, 8th, none of those. The circuit court of the county. There are 13 judges currently sitting in the 17th circuit, on the 17th circuit. The court's activities are divided in the following functions: administration and adjudication support services, circuit court services, family division, juvenile programs, friend of the court. Do you see anywhere where it says judge of the circuit court? Right, to make a judicial determination? No, this is all administrative bullshit. They're executing the law. They're not judging the law. And they get you to go to court in a case that technically doesn't have any controversy because you haven't gone to the court to say, hey, I object to what the hell's going on out here. They've never heard from you. They just assume you agree. Your silence is acquiescence. How the hell does that happen, you may ask? I don't know. One more thing on here. This is for anybody that gets a ticket, right? And they're doing it all by computer now. And so when the ticket prints out, it's going to have all the information on there. And this says that electronic filing of a citation. This rule applies to all civil infractions and misdemeanor actions initiated by the ticket. That's what all this bullshit is here. Ticket, ticket, ticket. Citation, complaint, filing. A citation may be filed with the court either on paper or electronically. The filing of a citation constitutes the filing of a complaint. An electronic citation must contain all the information that would be required in the if the citation were filed on paper. A citation that contains the full name of the police officer or authorized local official who issued it will be deemed to have been signed pursuant to the law that says you got to sign your freaking complaint. Contested actions. If an electronic citation is contested, the court may decline to hear the matter until the citation is signed and filed on paper. A citation that is not signed and filed on paper when required by the court will be dismissed with prejudice. Well, isn't that interesting? So what court are we talking about here, right? First of all, when you look at the citation that you get electronically, it's not going to have the officer's full name. It's going to have like TPR for trooper, an initial, and a last name. Your full name is your full name. Robert Allen Ritlewski is my full name. Right? Given name coupled with your surname, last name, family name. Take your pick. Go look up the definition of full name. That's what it has to be on there. If it isn't on there, it hasn't been done properly. So then they would have to go ahead and sign it by hand. If they won't sign it by hand, the court's not going to hear the case. Right? And so, are they talking about, my question is, are they talking about the circuit court? Is the circuit court the one hearing traffic tickets? Because this has to do with traffic tickets. This here is a traffic ticket issue. And, you know, as strange as it sounds, yes. The guy that hears the traffic ticket cases also hears murder cases, according to the definition of recorder in Wikipedia, where it says these recorders in New York sit on traffic courts and hear murder cases. Well, that, you know, not just anybody is going to sit on a murder case. It's that they're going to make. If they're going to actually take somebody's life, it will be done by the law. It doesn't mean that somebody didn't commit perjury, and they find out later that somebody committed perjury and told a lie. I'm just saying that the paperwork process is going to be by the law. And looking at some other states like Indiana or Illinois, it says in there that when they got rid of the city courts, they made the city courts circuit courts. Right? The municipal courts are circuit courts. That judge sitting down there, the judge, can be or is working for the circuit court. And so he's the one to bring this shit up to, instead of sitting there mute and say they're simulating the legal process. Or don't wait that long and put your complaint in to the Circuit Court of the county. And we got to find out who that is. Well, this is how I've determined it to be. If you go and get a certificate of authority for a notary, and so for those that don't remember, we were doing pleas of the crown and trying to make public records, and a public record requires authentication of the notary. Long story short. Well, how do you get that done? Well, as it turns out in Michigan, because a notary is a commissioned officer in the county. Commissioned officer, think about that. Military. Commissioned officer in the county. You would go to the county clerk to say, hey, I just had this notary notarize some paperwork for me. I need to have a certificate of authority for them. And they give you a piece of paper. It looks something like this. Whoever the clerk of the said county and clerk of the circuit court of the county of Montcalm, which is, okay, circuit court of the county of Montcalm, right? That didn't say 8th, because I close it down. This is Montcalm. This would have been the 8th Judicial Circuit Court. That ain't what this says. Clerk of the Circuit Court of the county of Montcalm, which is a court of record having a seal, do hereby certify that blah, 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 blah. And you can't see it, but right here there is a seal that says the Circuit Court of the county of Montcalm on it. Very similar to this one that came from Kent County, where I, Mary Hollenrake, clerk of the county of Kent, and also clerk of the Circuit Court of said county, the same being a court of record, do hereby certify that blah, 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 blah. And this thing here says seal of the Circuit Court of Kent County, Michigan. This is it's a clerk's office. Very similar to this one that I've shown before in this document, where this says Circuit Court of Bay County, Michigan. And I believe that probably says seal right there, S-E-A-L, seal. That's the seal. All right, that's their seal. This one says seal on the outside rim. And the one you can't see right here says seal on the outside rim. Point is, wherever you got this from, well, that's the clerk, the keeper of the seal for the court. So you would write your complaint up and take it to that office. You write your complaint up, it's going to be sworn to, so you're going to have a notary, put their notary seal on it, and then you're going to go get the certificate of authority. And when you get the certificate of authority for it, say, boom, excellent, and give it to them. So I need you to give this to the judge of the Circuit Court of the county. Now, they're probably going to say they don't know what you're talking about. Say, that's not my problem. You've been served. Make sure he gets it, right? So you probably want to get 2 copies because you're going to leave them a copy. Don't walk out with it. You went there to give them the paper, leave the paper. And say, you've been served. Is this not the office of the clerk of the Circuit Court of the county? Is that not the seal? That makes you the clerk. Index the damn thing and give it to the judge. Or are you part of the insurrection? Right? So, yeah, they do exist, right? I didn't know. I was just here recently. So, well, holy shit, we do have a circuit court for the county. There it is. And because of that, how are we going to use it? Well, apparently in Michigan, if you got a complaint against an attorney, you take it to the Circuit Court of the county. And it's not the 18th. There is only one circuit court. In the Court of Justice, there is one circuit court. All attorneys are part of it. So it doesn't matter if he's my attorney or not. If it's another attorney who's brought fraud upon the court, I can take it to this guy. Have him look at the record, right? I need a judicial determination. Did this guy just bring fraud upon the court? Okay, that's what those look like. So we're going to look at some other oaths real quick. But before we get to looking at the oaths, Write this down. Outline of Official Oath and Bond Requirements, 2013, Texas Association of Counties. If you Google that, you'll find this book. Outline of Official Oath and Bond Requirements. Probably all you got to put in. This tells who needs to take an oath, how it has to be done. It's pretty fucking informative. Excuse my French. Official oath and statement required. Okay, so now some of this just applies to Texas. I'm not going to say it's everywhere, but Texas, right? Close enough. Before taking an oath of office, all elected or appointed state officials are required to sign a statement of officer, a bribery statement. Some places I think you have to do, like in Michigan for the school board, you got to do an acceptance of office. And I haven't looked that close on that term yet, but I'm sure that every office you have to accept the office, right? An offer's been made, you need to accept it. Before entering upon the duties of office, all elected and appointed officers are required to take an official oath. So they got to do this statement and take an official oath. Texas Government Code provides that official acts of a person who fails to qualify as an officer are void. So if they don't take a valid oath, everything they do is void. Additionally, a person who has not qualified for office is not entitled to receive payment as an officer or exercise the powers of jurisdiction of the office. Without having qualified for an office, a person has no right to the position. However, where an officer has taken the oath and given a bond, which has been accepted without objection and not questioned at any time during the term, the officer may nonetheless be held to be de jure officer even if the qualification was not in strict compliance with the law. Until you bitch about it, they're the judge. Until you bitch about it, he's the county treasurer. Until you bitch about it, she's the county clerk. Until you bring up the fact they didn't take the proper oath. An oath in this state may be administered and a certificate of the fact given, right? So if I ask them for a copy of their oath, they better give me a certificate that certifies that, where is that thing? Oh, Alabama. Complaint, Michigan Circuit Courts, Common Law, Subordinate Magistrates. I got too many things open. I'll look at these just in a second. Damn it, Bob. Oh well. On my certified copy of record of birth, it says at the bottom they certify, right? It's a certificate saying that the information is true. You don't just get a copy of the oath. No, it's certified that it's true. Who must take an oath? Simply put, the oath is required of everyone who takes an office under authority of the state or its subdivision. The lack of requirement for an official oath into law creating an office is not a factor. Doesn't have to say it. If they're taking an office, they got to take the oath. Elected officers. According to the Texas Secretary of State, a person elected to full term may not take the oath before January 1st following the general election at which the person was elected. That's very important, right? They can't take the oath until after January 1st. Okay, so let's go look at some of these real quick. Where were those ones from? Branch County. Oath of office. I do solemnly swear I support the Constitution of the United States and Constitution of this state, and I will faithfully discharge the duties of the office of 15th Circuit Court Judge, Branch County, according to my best of my ability. Right? So what do we have here? Well, this isn't the guy's full name. Right? P. Dot ain't going to make it. My opinion. Right? They're going to have to prove that to me. But the other thing is there's no date on this. When did he take it? Right? He didn't swear it before anybody. This seal here, although it's quite interesting, is the seal they put on it when you go get a copy. Branch County Circuit Court. Official certified copy of original document on file. That's what I want. I want an official certified copy of an original document on file. Not just a copy of something. I want the original document. Certified copy of it. Remember that. Okay, so this is a certified copy of the original, and this original shows that there's no date. He didn't swear it before anybody. He's not holding the office. This is a usurper of an office. This man, P. Williams O'Grady, is a fucking usurper of a judge's office, and he needs to be cast out into the street. Then we got this one here for the county treasurer. Right? It doesn't have any seal on it. I don't know who the hell this is. This county clerk, Branch County, Michigan. It doesn't have her name written. Who is this? Taken as subscribed before me, this someday, December, whatever, right? County clerk, Branch County, Michigan. Where's your seal, clerk? There's no fucking seal on it. And you certified to it here that there's no seal on the original. And this person took it on the 20th of December. And according to this, if you've been elected to a full term, you can't take the oath before the 1st of January. Now, I know this is Michigan and this is Texas, but I'm still going to make him answer the question. Is that your testimony? That you followed the law? I'm sure someplace you look hard enough, you'll find it in Michigan where it says they can't take it until after the 1st of the year. Well, that was on the 20th of December. Don't need to go any further. This is the 19th of December. This one's for the county clerk. County clerk, you know, apparently this is a deputy clerk. But again, there's no seal on it. Now you look at this, it's like they're covering up the bottom of this piece of paper. And they just stuck this on top of it. Crazy the way they do this. So, right, they're certifying that there's no oath on file for the county clerk. So the county clerk isn't the clerk. If that's the case, then the county clerk can't take the oath as the county clerk for the treasurer. Either way, this was signed on the 20th. This on the 19th. The other thing is this oath that they took isn't this isn't by the Constitution because it added the words "so help me God" to it, and that's not what's in the Constitution. And they got Constitution capitalized here, Constitution capitalized there. Constitution, both Constitutions are capitalized. Same here. This one doesn't have a date. He didn't do it in front of anybody. He just filled out the paperwork himself. So here you go. You're not even trying. He's not a judge. He's a usurper of an office. The office has been vacated. Got to tell the county sheriff that, you know, this man has usurped an office. Now here's one for a judge in Illinois that, you know, looks somewhat better. Except it was taken in front of some other judge here. Chief judge of what? That's not his title. I mean, you know, if you're chief judge of what? But the big thing on this one is the fact that over here, upon receipt of executed oath of office, the declarant to be placed on payroll of the judicial branch of the Illinois on some day by this blah blah blah, right? It hasn't made it to this office yet. This guy isn't a judge. He's not on the frickin' payroll. Right? Another David P. Clement is a usurper of an office. Township oaths. That's what we got here in Michigan, right? I, Greg Dean. Okay, well, hang on here. Let's look at this real quick. Okay, I had written this for Jerry when I did those other oaths there. The clerk and the treasurer did not take the oath mandated in the 1963 Constitution as the word "so help me God." But it's confusing because in this section where it talks about county officers taking an oath, each of the officers named in this chapter, except notary publics, interesting, notary publics and prosecuting attorneys, shall before entering on duties of his office and within 20 days, official notice of his election, or within 20 days after the commencement of the term which he was elected, take and subscribe the oath of office prescribed by the Constitution of the state before some officer authorized by law to administer oaths. Right, got to go before somebody who can take the oath, and deposit the same with the clerk of the proper county, who shall file and preserve the same in this office. Now, here are the compiler's notes. This section, as originally enacted, was numbered section 119. Well, now it's 318. What, so I'm confused why the numbers changed. This section, as originally enacted, was numbered section 119. In this section, the Constitution of the state evidently refers to the Constitution 1853. Now see, CONST period 1963. Why didn't they spell it Constitution, and say what the name of the Constitution is? What is CONST period 1963? Does that thing even exist? The Constitution of the state evidently refers to the Constitution of 1835. How do I know that? What tells me that? This whole thing is hokey how this is written, but at the end of the day, let's say it was the 1835. Well, in 1835, I do solemnly swear or affirm that I will support the Constitution and Constitution. They're both not capitalized. 1963, Constitution of the United States is, and the Constitution of the state isn't capitalized. One is and one isn't. In neither case do you put your name in, and in neither place to say, "So help me God." No other oath, affirmation, or religious test shall be required as qualification for an office or for any office or public trust. Yet here, I, William Greg Dean, they put his name in. Boom, it's not the right oath. "So help me God." Boom, it's not the right oath. Right? Linda L. Martz. Boom, there's no seal. It isn't properly done. So this one's for the supervisor, and this one's for the board of review, and board of review, and board of review. I have the treasurer in here, but they're all the same. They all read the same, right? They're all incorrect. They added "So help me God." They put the guy's name in it. They don't have a seal on it, right? It's improper. They're usurping the office. And as it turns out, this isn't the township anyways. The townships are election precincts. We got so much to cover. There's just so much crazy stuff. Okay, but this is the oath that a notary takes, because this up here, right, this said "except notary publics and prosecuting attorneys." Everyone else is going to take the oath in the Constitution. This one here. Or 1963 would be this one. But a notary, somebody is asking you, right? It's not "I do," where you're filling out a piece of paper. It's "do you," which means somebody's asking you, "Do you solemnly swear that you will support the Constitution of the United States, the Constitution of this state, and that you will discharge the duties of the office of notary public and enforce said county to the best of your ability?" That's taking an oath. Swear to it, yes or no. After the oath is administered, so now this is some stuff from the Secretary of State's office talking about notaries. So after the oath is administered, a verification is completed by the county clerk or their designee attesting that you swore to the statement. Right? They're going to put a verification statement on there. And pursuant to this same rule, attorneys in good standing with the State Bar of Michigan are only required to file an oath in the county. No bond is required. Well, attorneys have to file an oath. Why is that? Well, because according to 55-271, Notary Public Qualifications, Secretary of State appoint as notary a person who applies to the Secretary meets all the following qualifications. Blah, 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 blah. What they're saying is all attorneys are notaries. If applicable, has filed with the county clerk or his or her county of residence or accepted appointment of proper surety bond and oath taken as prescribed by Constitution in the format accepted to the Secretary. The requirement of filing a bond does not apply to an applicant that demonstrates in a manner acceptable to the Secretary licensed as an attorney at the law. Licensed as an attorney at law in the state. Well, if they have a license as an attorney at law in the state, then the Secretary of State should have a copy of it. It says licensure. I don't know what licensure is. I thought it said license. Licensure. Is that a mistake? Or is that a word that's got a particular meaning that somebody should look up to see? What does licensure as an attorney at law in this state mean? Notarial acts means acts that the laws of this state authorize notary publics of the state to perform, including administering oaths and affirmations, right? Those are notary acts. Well, then who's a notary? A notary public is a judge, clerk, a deputy clerk, right? They're notaries, because only a notary can do a notarial act, which is to administer an oath. That's a notarial act. Notaries are ecclesiastic offices, by the way. An officer of foreign service in the United States, a counselor, a commissioned officer in active service, right? So if you have a commission, does that make you a commissioned officer? I don't know, man. They're talking about having a commission. They gave a notary a commission. Does that make him a commissioned officer? Commissioned officer of what? Any person authorized to perform a notarial act in the place in which the act is performed, satisfactory evidence, blah, 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 prosecuting attorney. Because the notary, because now people here in Michigan, you need to go check on the oath of the prosecuting attorney. Let's find out who it is, because the person so appointed shall, before entering upon duties of his office, and within 20 days after receiving notice of his appointment, appear before the county clerk and take and subscribe the oath of office prescribed by the Constitution, and file the same with the clerk, who shall thereupon deliver to the person so appointed the commission received by him for such person. Go to the county clerk and ask for the commission that was given to the prosecuting attorney, and shall thereupon give notice to the Secretary of State of the filing of such oath at the time of filing the same. We want to see the commission. Does the prosecuting attorney have a commission? If not, he's usurping the office. And again, this section was originally enacted, was numbered 124, and now it's 123. Right? I don't know. They're playing with the numbers here. I don't know if it's on purpose, if this compiler's note still matters. It's good questions to ask the sheriff. Alright, now this one here looks like it's been done properly. This is Pierce County Auditor. State of Washington, County of Pierce, date received, right? It's been filed into the county. I don't know if this is what their Constitution says to take, but I do solemnly swear I'm a citizen of the United States and a resident and registered voter of Pierce County, and I will support the Constitution of the United States. The state of Washington, you really want to go look at this guy's election paperwork to see how he did it, because it's probably what we need to do. So this guy is sworn before me, a chief deputy auditor, and it's got the seal of the court on there. Right? This looks like it's been done properly. This could be the sheriff of Pierce County. And we looked at that. Oh, I wanted to show you this. That's what I was looking for before. Right, when I talked about the clerk putting a certificate on after they swore to it, right? In testimony, therefore, I have hereunto set my hand and affixed the seal of the circuit court, blah, blah, blah. County clerk, deputy clerk, seal. To me, that's the verification after you've taken the oath that you've taken the oath. You make a certificate of it. Right? This is how they certify. Now, here's an oath for a who is this for? A coroner. Look at grantor and grantee. The grantor is the guy taking it. The grantee is the public. Well, what do we know about oaths? If you're the grantee, you need to accept the oath. You need to accept the deed. Grantor of a deed. Grantee of the deed. Grantor of the promise. Grantee of the promise. I accept your oath. Bind you to it. Remind you have a fiduciary duty. Extend you my sovereign immunity while you carry out my orders. But I didn't take an oath to you. On contraire. Right, I'm an elector of the state. I'm a man filled with the Holy Ghost, right? Are you going to deny the Holy Ghost? Especially if it says on the, see, this one doesn't say on here, so help me God. If it says so help me God, because most of them do, you say you call God in as a witness. I'm a man filled with the Holy Spirit. I'm here as God's witness to make sure you fulfill your duty. Unless you're going to deny the Holy Spirit, and that's the only thing you can't be forgiven for. As Jesus said, you can blaspheme the Father and be forgiven. You can blaspheme the Son and be forgiven. But if you blaspheme the Holy Ghost, you will not be forgiven on earth or in heaven. Yeah, tell him you're filled with the Holy Ghost. Go ahead, blaspheme now. And this looks like it has the same seal as the one we looked at just a minute ago for the auditor. Right? This looks like a properly done oath. Except it was done on the 29th day of December. And if this guy was elected to the office, right, and you're supposed to wait till after the 1st, well, then that would be the mistake, is it was done too soon. Can't take the oath until after the 1st of January. Yeah, elected for full term. There you go. Election date, November 7th, 2006. Elected for a full term. And according to Texas, full term may not take the oath before January 1st following the general election in which the person was elected. It all looks good, except he took it too soon. He's not holding the office either. Usurper! They're usurping an office. Go tell the sheriff. Who's the sheriff? Who's the sheriff? Again, it's the... that's what we need to find out, who the sheriff is. I say it's the guy that runs the county court. I say it because Blackstone said it. Okay, what do we got here? This is a oath of a deputy. I, somebody, do solemnly swear, blah, 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 blah. So they put their name in it. And again, I don't know if you can put your name in it. According to the best of my ability, doesn't say so help me God, so that looks okay. Faithfully discharge the duties of deputy clerk in the office of circuit court. Right, so this is the office of the circuit court. That's good. Didn't say 16th Judicial Circuit, because they do have that. Thomas is the clerk of the circuit court, or the circuit clerk of the circuit clerk. Now, how can you be the clerk of the circuit clerk? What does that mean? I'm the clerk of the circuit clerk. Then who's the circuit clerk? Because you're his clerk. You mean the circuit cleric? You're talking about the County ordinary could be. Problem is, where's the frickin' seal? No seal. I don't know that you are the clerk of the circuit clerk because you didn't put the seal over here. Usurper. This is even filed into a court case, right? They got it. This is a court case number, 13MR01. Office of the Kane County Circuit Court Clerk. Right office, Kane County Circuit Court Clerk. Interesting. I don't know what it means. Except there's no seal on it. That's what I know it means. And so this Thomas, he's the clerk of the circuit clerk, and he's the clerk of the circuit court. Or he's the Kane County Circuit Court Clerk. And he's the clerk of the circuit clerk. Well, who's the circuit clerk? There's a building in Kane County. When you walk in, it says circuit clerk on the building. And in that building is where all the records are. Almost like that's really the chancery. That's where the circuit cleric is. Clerk of the circuit clerk. Interesting. Some for Roe to ponder. What do we have here? When you notarize a signature, you must perform one of two official notary acts. Take an acknowledgement or administer an oath. Two things you do. An oath or affirmation is administered to a document signer when the signer is required to make a sworn statement about the facts. The signer personally appears before you to swear or affirm to you, and officers duly appointed to administer oaths that the information contained in the document is true. A notarization requiring an oath begins with the administration of an oath or affirmation. The courts have held that there should be a verbal exchange between the notary and the document signer in which the signer indicates that he or she is taking an oath. An oath similar to one administered in the court by judge or bailiff would be sufficient, or you may simply ask, do you swear or affirm that the information contained in the document is true? That's all you got to do, just say yes, it's oath. Boom, you're done. Note, the form, certificates, and winner, and here, I could make it bigger. Used when taking an acknowledgement or administration of an oath are found in the Notary Law, Section 117.0513, Florida statutes, and are printed on page 30. Unfortunately, this wasn't in there. The form certificates used when taking an acknowledgement or administering an oath are found in the Notary Law section. So if you're going to fill out your own paperwork in Florida and you want to know how your shit should look for the notary to put her stuff on, you would go to Notary Law section 117.05, section 13. Or whatever, 13. But kind of, it's going to look like this in an affidavit. Before me this day personally appeared somebody, and being duly sworn that he swears it is true, deposes and says that the facts stated on the paperwork are true. Fill in the paperwork. The signature of the affiant, sworn or affirmed, subscribed before me. This is where the notary fills out. Boom, boom, boom. And they put their seal. Alright, so everything that's done as far as an oath is a notary act. Notarial act. So any judge, attorney, whoever, they're all notaries. And they all have their commission held. Because they're all notaries, they all have their commission held in the county clerk's office in Michigan, which is actually the clerk of the circuit court of the county. I don't know who the judge is, but I know that she's the clerk. And if you're going to bring something to court, who do you give it to? The clerk of the court. Well, I want to file a complaint for whatever. We're going to look at a simulated legal process here shortly called a foreclosure in Michigan. Point out some errors and say, okay, well, here's something. Now, we need to write the paperwork up yet, but that's the idea. You take it to the place where you would get the certificate of authority. Now, not every state does it that way, right? Not every state has the same thing. So I can't tell you where you're going to find yours. You need to think about it a little bit based on the evidence provided. You want to do that? We cover most of these. Yeah, I think we got most of them. Coroners, how else are done in Texas? Judge's oath. Township oaths. Oath analysis. This is the oath that they take in the bar. I do solemnly swear I will support, I will maintain respect and due to the courts of justice and judicial officers. You better not bring fraud on the court. You better not be suing in the name of a fictitious entity. Right? You better not have any errors or omissions in your paperwork. You better not tell me you don't need a frickin' sworn complaint. I will not counsel or maintain any suit or proceeding which shall appear to me to be unjust, or any defense except such that I believe to be honestly debatable under the law of the land. So they're not going to offer any defense unless it's going to be debated. Well, fuck that. I mean, excuse me again, but no, I don't want to debate it. I want you to say there's malicious prosecution because they didn't swear out a complaint and somebody's committing perjury. And that's not debatable. The evidence is there. It's in the paperwork. Honestly debatable under the law of the land. What is the law of the land? If that's that freaking Magna Carta, the Constitution of the Jewry, I want nothing to do with it. These guys took an oath to be under the Constitution of the Jews. And in the Constitution of the Jewry, well, you can go ahead and you can screw a Gentile or a Christian. Back in the day when all this stuff was in place, that between the 10th and 12th centuries, up until the time of the Magna Carta, there were a series of contracts between the Jews and the kings, and the Jews became the king's property. And because they were the king's property, they had the king's protection. And if they got to run their own courts, and if they brought you as a Christian into their court, they could screw you. They could do it by their own laws, which is the Talmud. Go read about the Talmud or watch some videos on it. And so you, as a Christian, would have to go to the king's officer, who would be the sheriff, apparently. He's the officer in the county. Say, hey, man, I'm being tried over here in this court of the Jew, and I'm a Christian. I got nothing to do with them people. Because you were not going to win in that court. There's just no way it's going to happen. And that's what you find yourself in today. Protestant legalism. Gotta love it. I will employ, for the purpose of maintaining the cause confided to me, such means only as are consistent with truth and honor, and will never seek to mislead the judge or the jury by any artifice or false statement of fact or law. No, I'll just mislead my client so that I can take him in a path that I don't have to put in a false statement. I just won't put in a proper defense. That's crazy stuff. Anyways, we go on and on about that stuff, but I don't want to. Let's get on real quick to a few things that we found in Kane County. Right? Kane County has got its ordinances are online. And in those ordinances, it talks about these standing committees. And in these standing committees, they, I don't know how many, they got a bunch of them, and they're all of interest, but because of time, I'm going to get to the ones of the most interest. You got the executive, which pretty much has all the board members of all the different things, right? And they have this committee shall also have jurisdiction over approval of all official bonds, right? If you're looking for somebody's bond, go talk to the executive committee and find out where's the bond for whomever. They have jurisdiction over the approval of all official bonds. Each county official furnishing a bond for approval shall be requested to obtain at least 3 sealed bids from corporate sureties, if corporate sureties are required by the committee. They're going to know where the bonds are. They shall have jurisdiction over all matters of the county budget. Yada yada yada. This one I want to get to. Judicial and public safety. This committee shall have jurisdiction over all matters pertaining to the office of the state's attorney, the public defender, the police functions of the office of sheriff, and the coroner's office. Right? Well, if you're looking for, they tell you that if you want to put in a complaint, you need to go to law enforcement. Okay? Well, the law enforcement is the police function of the office of the sheriff. Go to the Judicial and Policy Safety Board and say, I need to put in a complaint. You have jurisdiction over the police functions of the office of the sheriff. This committee shall also have jurisdiction over Department of Youth Home, Diagnostic Center, Adult Corrections, Court Services, Juvenile Delinquents, or Juvenile Services, Adult Probation. Man, that sounds a heck of a lot like the things that the sheriff is over. Shall have jurisdiction over all matters relating to the courts and the judiciary. To the judicial functions of the sheriff's office, such as bailiffs and process servers. Right? They have jurisdiction over all matters relating to courts and judiciary. Man, they're not following the law over there in that court. Here's the proof. Here's the court case. The committee shall have jurisdiction over the office of the circuit court clerk. Right? You're not hearing what you want to hear? Well, you go to this office and bitch. Judicial and public safety. Then you got one for public health. This committee shall also have jurisdiction over the Office of the Emergency Management. Public service. This committee shall have jurisdiction over all matters relating to the office of the county clerk, recorder, superintendent of education, service region, veterans assistance, collector, board of review, supervisor of assessments. This includes but not limited to approval of purchase and supplies, yada yada yada, tax extension functions, voter registration, compensation of judges of election supplies. This is Roski. This is who you need to go talk to about the judges of election. See, one of the things that's happened, this is how crazy this system is, and how simple it will be to fix. We are all supposed to be registered electors within a municipality, within some small self-governing district. And as it turns out, these are probably the election precincts, because that was the idea of Thomas Jefferson and his ward, W-A-R-D, ward republics. Could be a school district, could be an election district. If it's a school district, though, I don't believe it's the school district with the high school and the 5 or 6, 7, 8 grade schools. It's a school, and the district around a school that it would take people in, because they were supposed to be smaller than like 10 miles square, not 10 by 10, 10 mile square, 2 by 5. That's the way I read it. Right? So most of these school districts, when you look, they were like 9 miles square, 3 by 3, under 10. So because we haven't registered as an elector, we can't tell the township, because again, the township is actually an election precinct, as it turns out. We can't tell them what to do. Where is that? Real quick, man. I just want to show that to you. That's crazy stuff. That's not the one. This is in a book. Illinois townships are election precincts. Each town acting under township organization shall constitute an election precinct, and the supervisor, assessor, collector shall be ex officio judges of elections. Each town acting under township organization shall constitute an election precinct. Well, as it turns out, in Illinois, right down the road from the township hall is the road district, and it's in the town hall. You got a township hall and a town hall. Each town acting under township organization shall constitute an election precinct. That's actually the and it has a supervisor, assessor, collector. It's a self-functioning government. It's not what you think of as the township. It's the election precinct, is the actual municipality. The county judge, see, this is how you found the county judge, right? The county judge sitting in the county court without associates in counties acting under township organizations shall have the same jurisdiction of suits brought by collectors of taxes on delinquent lands and town lots as county courts have under existing laws. So this shit's all happening local. They put some small ass lien against your property. Because the other thing that these people can do, all right, so we have all these boards, right? Blah, 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 blah. And okay, so I'm running out of time here. So again, from the same Kane County ordinances found online, there's certain things that they can give you liens for. Anytime prior to issuance of a building permit, they have an impact fee payment agreement, right? Where because you're going to be affecting the road system, you're going to have to pay some money. But you can do an agreement but prior to getting the building permit, you can get a form of security at sole option of the county. Be required to secure the deferred payment of the impact fee due under the provision of this article. Security may be in the form of promissory note, cash bond, security bond, or irrevocable letter of credit, or a lien or mortgage on lands to be covered by building permit, among other things. So they're going to put a lien against the building when it was first built on the building permit because you didn't pay this impact fee, and they can come back later and collect on it. They can put a lien on your property for noxious weeds, right? If you're growing dandelions in your yard, they can say it's a noxious weed. Now the interesting thing is, excluded from the provision of this subsection are prairie plants, lands or portions of any lands located in a public nature area, and any property owned or leased by a unit of government. It doesn't apply to them, right? But whatever a noxious weed is, if you have one, they can put a lien against your property. And they do it with an administrative adjudication. And the health officer can put one against your property. The long-term maintenance, this is about stormwater drainage. This is the drain commissioner. You're responsible for the stormwater drainage system within your property. Right? They can transfer the system to the homeowner or similar association, or convey it to one or more persons. If the owner does not do so, and place a lien against the land thereof, and right, so they just put liens against your property using an administrative adjudication, which is like a court process, but it's and the other thing is, did you ever get a certificate of occupancy? Right, until you have one, the house isn't completed. And they don't want to give you a certificate of occupancy. But they're doing it with these administrative cases, administrative hearings. Right? Per adoption of a system of administrative adjudication, 55 Illinois file statutes. Administrative adjudication of county code violations. Any county may provide by ordinance for a system of administrative adjudication of county code violation to the extent permitted by Illinois' Constitution. An ordinance establishing administrative adjudication pursuant to this division shall provide for code hearing unit. They can hear testimony, they can issue subpoenas, they can preserve and authenticating of the records, issue a determination. All those things can be done. Impose penalties up to $50,000. In addition, every administrative hearing officer must be an attorney licensed to practice law in the state of Illinois for at least 3 years. A proceeding before a code hearing unit shall be instituted upon the filing of a written pleading by an authorized official of the county. All right, so you got dandelions growing in your yard. Some guy walking the dandelion patrol is going to come around and say, hey, this guy's got dandelions. I want to issue a warrant. Start a process. Any ordinance establishing a system of administrative adjudication pursuant to this division shall afford parties due process of law, including notices and opportunity for a hearing. Now, what if you don't get the notice because they have your address incorrect? Like on Rose's warrant, they had her address as a different freaking zip code than her zip code. Parties shall be served in this process in a manner reasonably calculated to give actual notice. We'll pretend that we mailed you a notice. Parties shall be given notice of adjudicatory hearing that includes the type of nature of code violation to be adjudicated, the date and location of the hearing, legal authority, so forth and so on, right? But did you get the notice? You need to go there and say, hey, do you guys have any what will we call them? Abstracts of judgment for any administrative hearings you had against me. Parties shall be provided with an opportunity for hearing during which they may be represented by counsel. Rules of evidence shall not govern. The formal and technical rules of evidence do not apply in an adjudicatory hearing permitted under this division. Evidence, including hearsay, may be admitted only if it is a type commonly relied upon by reasonably prudent persons in conducting of their affairs. Well, who's going to be the judge of that? I guess they are. Enforcement of judgment. Right? It's a debt due and owing the county after expiration of the period in which judicial review under Illinois. So there could be a judicial review. This is an administrative hearing. It's not judicial. There could be a judicial review if you knew that you were supposed to have gone there and, could go and say, I want to have a judicial review of the decision you made by not letting me know that I had this against me. Unless stayed by a court of competent jurisdiction, the findings, decisions, and order of the hearing officer may be enforced in the same manner as a judgment entered by a court of competent jurisdiction. Shall be a debt due and owing the county and may be collected in accordance with applicable law. In other words, they can put a lien against your property. The county shall provide notice to defendant. The states the defendant shall appear to determine whether the defendant has failed to comply with the judgment. Notice shall set a date, so forth and so on. If notice is served by mail, a 7-day period shall begin to run on the date that the notice was deposited in the mail. But did they use the right address? Upon being recorded in the manner required by Article 12 of the Code of Civil Procedures, a lien shall be imposed on the real estate or personal estate or both of the defendant in the amount of the debt due and owing to the county under this section, and that's enough to take your property. They'll go ahead and sell your property then to pay the debt. You really got to find this administrative hearing. This is probably where your foreclosure actually happened at. The division does not affect the validity of systems of administrative adjudication that were authorized by state. Oh, this is just adding to it, right? If that wasn't enough, we've added some other ones. There was something here about, in case you didn't get the notice, it's really not their fault. Okay, but this goes to show that there's an administrative adjudication, and, they're running it like a court. They can issue subpoenas. They're administrative subpoenas, which when you look up administrative subpoena, it says in Wikipedia that they're unconstitutional. Or people have claimed they are. Other people have said, wow, they're real handy means of getting shit done, even though it's unconstitutional. What about our local emergency manager? What's his job? There is hereby created a county emergency management agency to prevent, minimize, repair, alleviate injury and damage resulting from disaster caused by enemy attack, sabotage, or other hostile action, or from the nature or man-made disaster. To me, it's a man-made disaster when people aren't following the law, that are the ones writing the law. That's a man-made disaster. How in the hell did you ever get that position? God didn't do this. Man did it. It's man-made. It's enemy attack, sabotage, hostile act. It's all those. It's a frickin' insurrection. Call 911 and put in your complaint. Write a complaint, take it to the County Emergency Management Agency. Right? emergency management, it has jurisdiction over man-made disasters. Now here's the oath they take. Now they got a space there to put your name, so they must mean for you to put your name. There's 2 commas, so must be you put your name in there. Do solemnly swear or affirm that I will support and defend and bear true faith and allegiance to the Constitution of the United States and the Constitution of the State of Illinois and the territory, institutions, and facilities thereof, both public and private, against all enemies, foreign and domestic, and that I will take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties upon which I am about to enter. And I do further swear and affirm that I do not advocate, nor have I ever been a member of a political party or organization that advocates the overthrow of the government of the United States. Well, we got people out there that aren't following the law, so there are, and it's your job, emergency management, to get rid of them, of the United States or this state by force or violence, and that during such time as I am affiliated with Kane County Emergency Management Agency organization, I will not advocate nor become a member of any political party or organization that advocates the overthrow of the government of the United States or the state by force or violence. Put a complaint into the emergency manager of your county that they're not following the law. If, for instance, if you've been given a traffic ticket, and you watch the video I did just before this one, you'll see in there that, in these traffic tickets, they're supposed to file an abstracted judgment with another state office. In Arizona, it's the transportation office. Michigan, it's the Secretary of State's office. Ohio, it's the Bureau of Motor Vehicles. Wherever it is. But if they don't have it, well, then they didn't follow the law, and they're not going to have it because somebody has to certify that it was done properly. And the whole thing's a sham because it started with a frickin' ticket that nobody signed. Right? And if you're not going to stand up and open your frickin' mouth and say, hey, you guys are usurping the law, it's an insurrection, there's not much I can do to keep you from kidnap my ass and throw me in jail, but I'm going to tell you that you're breaking the law so that you know that I know and God knows now. And now if you do it again, it's on your conscience. Maybe you didn't know before, but now you do. I'm going to point it out to you. That's what Christ did. He said he came here because he had to show the Pharisees, hey, I'm the Son of God. All right, you've been waiting for me. Here I am. And they killed him anyways. Well, okay, now they could be destroyed. So he did. Pummeled their ass. And before he can come again, the weeds got to be burned. That's what we're working on. I'm going to go burn some weeds. Okay, one last thing real quick. We'll be done with this. This was a complaint. If you're in Michigan and you're in a foreclosure and you have something that looks like this. Alright, it's a DC 102C is the form. This applies to anybody, right? You just look at the damn paperwork they give you. That's all this is about right now. Going to look at what paperwork we get and see what it tells us. Okay, well, here's a pamphlet to fill out that form. DC 102C, complaint to recover possession of property. Usually you want to recover possession of real property. Okay, that's what it's for. Okay. So, without going through it step by step like I did, if we just take a look at what's on here and you were to read what the instructions are, so the easiest thing to do is get a blank form and act like you're filling a damn thing out. What's the instructions say? Well, the instructions say plaintiffs' names, addresses, and telephone numbers, and I don't see it. Defendants' names, addresses. Okay. Well, who's this TNT something? Who are they? I mean, Paul is, first of all, it should be listed each separately. Paul J. Van, Robin L. Van, all the documents. It's written together like it's one person. No, man. I mean, defendant's a defendant, right? Name them one after another. Boom, boom, boom. But who is TNT with this number as a defendant? Well, that's Trot and Trot. Must be something to do with them. Okay, and then I asked some questions. Paul had some things going on in the federal courts. They listed them, but they said the action is no longer pending, like it had already been taken care of. Paul says it hasn't been. This court number here, 130698LT, well, that's the court number of the case. So how could that have been a civil action between these parties or other parties arising out of a transaction or occurrence alleged in this complaint has been previously filed with the 59th District Court? Okay, well then it should have a different number, right? You're going to put this case in, and it looks like 130698LT, 13069. Like, to me, they're saying this court case was already in before. That's a small thing. Says there is a copy of lease or occupancy agreement attached. That's item 2. Okay, attached to this complaint is a copy of the lease or occupancy agreement, if any, under which possession is claimed, and a copy of notice to quit or demand for possession showing when and how it was served. Well, Paul says none of that was on there. All that was on there was a copy of the sheriff's deed. No notice to quit or demand for possession, right? No copy of a lease. None of that was on there. Right? So that's the first error. Hey, you guys didn't follow number 2. Does the sheriff's deed say who's entitled to property? Okay, number 3. The person entitled to possession of the property described in the attached notice demand, which they didn't check, so there isn't one on there, as follows. So they wanted you to put the name of the person here, not see the attached sheriff's deed. The person entitled to possession, what's his name? Right? Not X as follows. See the attached sheriff. No, what is his name? The defendant is in possession of all the following portion of the property. All the above captioned property the defendant is in possession of. Remember that. The plaintiff has a right to possession of the property because of A, B, C, D, E, F. I think F, other. Didn't put anything. Filled all this in below. Described in detail how the trespass occurred, how the premises being held. State that no lawful tenancy existed between the parties in the time that it was passed the trespass took possession. Defendants are wrongfully holding over after expiration of the redemption period, following a mortgage foreclosure sale upon information belief. Right. Upon information and belief. Well, who'd you get the information from and what do you believe? Where is the sworn testimony? Property is not occupied by a bona fide tenant, as defined in property tenants foreclosure, blah, blah, blah. Okay, the thing is, what they're writing here is D. Defendant is a trespasser. Explain in the space beneath item F. That's what's supposed to go here, that describe in detail the trespass. They're supposed to put on this block here the reason. There is no reason. They didn't follow the procedure. If applicable, the tenancy involved regulated housing operation under the rules under which the tenancy is ended. The plaintiff declares that this resident's property was kept fit. Yeah. Plaintiff didn't do anything. Right? The defendant remains in possession of the property. That's not checked. But up here it said the defendant is in possession of the property. All of the above captioned property. Right? They're saying that he's in possession here, and they're saying that he didn't say he was in possession here. Make him check the box. Plaintiff asks for judgment of possession and costs. Plaintiff demands jury trial. Now, the interesting thing is this is happening in a district court in Michigan, and district courts only have jurisdiction up to $25,000. So how is it they can take your house in a court that only has jurisdiction in matters up to $25,000? It's because they're not asking for money. They're asking for the property. They want the securities. They want the note. They want, they want the title. They're not asking for money. Now you look at the summons for this thing. Again, names and addresses. They don't have them. Got the plaintiff's attorney, but right, plaintiff's name, address, and telephone number. It's not on there. If you require, right, is this for a rental unit eviction or land contract forfeiture? It's the only two things that you can use a landlord-tenant land contract summons. Well, it wasn't for either. The plaintiff has filed a complaint against you and wants to evict you from address or description of premise. Okay? You are summoned to be in the district court on this date at the address above. What address? The address above is the house address. Right? There's no location. Where was I supposed to be? Right? And where were T&T? Were they there? Oh, okay. Distinction. Okay. Says it's a court clerk, but again, there's no court seal. So there's no court seal on it. There's no file stamp. There's none of that stuff. And if you read this book that comes with it, and you just were to go through step by step on doing it, you would see, well, yeah, you're supposed to fill all these things out. Right? This is the book they're supposed to follow to do it, and you get to page all right, fill in the district court number, court address, court telephone number. Write in the names and addresses and telephone numbers of the plaintiff and defendant. Check the box that you, the landlord, are the plaintiff. Now, the interesting thing, right? Can you use a you, the landlord, are the plaintiff. Where's the landlord? Right? Who was the landlord? Wells Fargo was a landlord? Check the box is true for you. If another civil case is filed involves you and the tenant regarding the same problem, stated in the complaint, write the name of the court where the case is filed, the case number, right? So the name of the court, the case number, and the name of the judge. Well, they didn't list and put the names of the judge. A, B, C, D, E, F, G, H, I, J, K, right? Got to follow the rules. Don't follow the rules, you didn't do the form right. Got to start over. That's what you make the complaint, is they didn't follow procedure. Not whether you owe them any money or not. Say they didn't follow procedure, judge, right? I wasn't properly served. I wasn't properly noticed. It's easy enough to fix. Have them go get the notice and bring it to me. I wasn't properly noticed. I swear to it. If they say, well, you were noticed, say, no, I wasn't. I was not noticed. I swear I wasn't noticed. Go get me the notice. Right? It's easy enough to prove. Go get the notice. Let's see what it looks like. So this goes through, this page here is the last page, right? So this shows where all those boxes go to, and this is all the things they have to do. And if you read through these, they haven't done these. So, okay. So I'm going to work on, so the idea now is this has already happened, and they got a sheriff's deed and poor Paul here may get kicked out of his house, so we're going to put something into the Circuit Court of the County. The Circuit Court of the County of Kent as a bill of complaint. You just got to sit back and fill it out right, because this is what we're doing. We're going to Chancery, right? That we're trying to get to the Court of Justice, and that will be the Court of Chancery. And the Court of Chancery, we used to have one in Michigan in 1848. It was absorbed by the Circuit Court, and they said the proper address to address the court was to say, in the Circuit Court for the county of whatever Kent, comma, in Chancery. That's the address. Bill, Chancery Practice. A complaint in writing addressed to the Chancellor, containing the names of the parties to the suit, both complainant and defendant, a statement of the facts on which the complaint relies, the allegations which he makes, an averment that the acts complained of are contrary to equity, and a prayer for relief and proper process. If office in a Chancery suit is the same as its office in a Chancery suit is the same as a declaration in an action of law, a liable in a court of amnesty, and an allegation in a spiritual court. So if you have an allegation against you, you are in a spiritual court. Not a Christian court, a spiritual court. You're in the court of the Jew. A bill usually consists of 9 parts. The address, which must be made to the Chancellor, court, or judge acting as such. So we're going to do it to the court. The Circuit Court, the County of Kent, comma, in Chancery. Second part consists of the names of the plaintiffs and their descriptions. Right? So how do you describe the plaintiff? Robert Allen Rutluski, comma, son of God. That's my description. But the description of the parties in this does not, it seems, constitute a sufficient averment. Or Robert Allen Rutluski, comma, baptized Christian. That would work. The third part is called the premise, or the starting part of the bill, and contains the plaintiff's case. The fourth part is the general charge of confederacy. The fifth part consists of the allegations of the defendant's pretenses and charges and evidence of them. The sixth part contains clauses of jurisdiction and the averment that the act is complained of is contrary to equity. The seventh part consists of a prayer that the parties answer the premise, which is usually termed the interrogatory. Eighth, prayer for relief. Ninth part, prayer for process. Now, anyways, there was a book that was put out in 1907 by a chancellor from Tennessee that I've talked about numerous times before. So I'm going to go look at that book, because I think in there it actually has an idea of the form. And pick out some very simple things, put it together. It'll be on the next video what we come up with. But the idea is who do you give it to? And it's the Circuit Court of the county, or the county court, or whatever they call it, wherever you're at. That's where it has to go to. And over the next bit of time, hopefully we get somebody that goes and asks the right questions in their state, gets the answer, and says, hey, here, it's this court. All right, you don't ask me, you're going to have to go find it yourself. I don't know where it is in your state. I don't even know where it is in Michigan yet. I just have some ideas based on things that I've read where I believe it is. And so we're going to go try to find it. And before we go, if you can, again, I can really use it. PayPal account is ashleyritluski@gmail.com. And Robert Ritluski, 10955 14 Mile Road, Rockford, Michigan, 49341. I appreciate your help. Thank you all. See ya.